Good afternoon, everyone, and welcome to this presentation by the TCPA Defense Force at Womble Bond Dickinson. My name is David Carter. I lead our TCPA defense team, which includes attorneys from throughout our firm that work regularly on issues related to the Telephone Consumer Protection Act, including both compliance and litigation matters. Just a few housekeeping matters before we get started today. First, all of the participants' lines are muted, so you will not be able to communicate with us through your telephone or through your computer speakers. However, there is a Q&A feature that's located on the WebEx platform, and you're welcome to type any questions that you may have throughout the presentation into the Q&A. It's our expectation that we'll move through the presentation and then use any time that's remaining at the end of the hour to address questions from the audience. So please don't hesitate to submit those. And if we want to run out of time during the presentation to address those questions, we'll be glad to follow up with you individually. Please do keep in mind that this is a public session. It is being recorded. So we encourage you not to submit any confidential information or to identify yourself if you would not like your question to be affiliated with you or your company. We are operating, of course, in these somewhat unusual circumstances, although after several months we're getting used to this new normal, as they say. But it is possible that even though we have a great technology team with us, that we might experience technical difficulties. If we do, we just ask that you remain patient and stay on the line, and we'll try to get things running again as soon as we can. And then finally, again, just a reminder that this session is being recorded. So today we are here to talk about recent updates related to the Telephone Consumer Protection Act, of which there are numerous. And so we've just broken down our presentation into 3 panels that will have 2 speakers for each of those panels. In the first panel, we'll be talking about the recent Supreme Court decision in Barr versus American Association of Political Consultants, which raised a First Amendment challenge to the TCPA. Next, we'll have a panel discussing the ongoing debates and disputes about what the definition of automated telephone dialing system really is and how it impacts your companies and with your use and outreach to consumers. We'll also touch on the Supreme Court's recent decision to grant cert in a case involving Facebook that's going to put this question directly at issue. Finally, we will discuss a recent decision from the Federal Communications Commission, which also involves the issue of what an ATDS is, but within the context of the specific peer-to-peer texting applications that you may be familiar with. So those are our 3 panels, and we're going to go ahead and get started. I'm joined for the first discussion by my colleague, Arteen Betpera.
Hi, everybody. My name is Arteen Betpera. I'm a partner at Womble Bond Dickinson and member of the TCPA Defense Force. My practice generally focuses on the TCPA. I handle both class action and individual litigation, and I provide advice and counsel on TCPA compliance matters to businesses of all sizes, large and small. I'm excited to join you today. I must confess, this is my first time in, I think, 4 months that I've actually dressed up, and it does feel quite nice. So I'm happy that you joined us today, and excited to talk a little bit about some of the big developments we've had this year in the TCPA. So if we can move on to the next slide. The first case we'll be talking about is the Supreme Court's recent decision in Barr versus AAPC relating to the constitutionality of the TCPA. David's going to go ahead and break down the opinion, and I will kind of lead you through the timeline of what got us to the opinion in the first place. And I think to really do that, it's important to start all the way in 1991 when the TCPA was passed. So when the TCPA was passed, there was a very broad auto dialer restriction that was passed that prohibited certain types of telephone calls based upon really 2 primary categories. The first, you have the technology used, and the second, you have the telephone line that's called. The main driving force of litigation, compliance issues, and everything is the TCPA's restrictions on auto dialing and pre-recorded messages. For the longest time, the TCPA kind of chugged along without too much in terms of litigation. That started to really change in about 2003 when the FCC passed one of the first robust rulings addressing what it thought the interpretation of an automatic telephone dialing system was. And they interpreted it fairly broadly to include many modern-day dialing devices that were far advanced from the kind of random blunt force type dialers that were in existence at the time that the TCPA was passed. That kind of ended up snowballing into very regular litigation involving the TCPA that in the early days spawned a few initial First Amendment challenges to the statute before there was a exemption in 2015 that led to the current case. Those initial challenges to the auto dialer restriction in general really didn't make it that far. They were rejected by lower courts and really never made their way up to the Supreme Court. Now, in 2015, Congress passed a bipartisan budget act that included a specific exception for calls made to collect on government debt. And this, by and large, made sense at the time, I'm sure. There were a lot of debt collectors being sued in both individual and very high exposure class action lawsuits for alleged failures to comply with the TCPA. That eventually ended up impacting companies that collected on government-backed debt. And a big example of that is student loans. And so the government carved out a nice little exception for themselves that said that these auto dialer restrictions passed in 1991 don't apply if the caller is calling to collect on debt owed to the government or backed by the government. And so what this ended up doing for some enterprising defense lawyers is it created this new constitutional challenge to the TCPA. Because all of a sudden we went from a statute that for 20 years was regulating speech, so to speak, based upon either the technology used to call or the phone line to which the call was directed, to regulating speech by what the speaker was saying. In this case, I'm calling to collect on government-backed debt. And so in 2016, you saw one of these challenges arise from an association of political consultants, the AAPC, that sued in the U.S. District Court in the Eastern District of North Carolina, making this very argument. And that eventually made its way all the way up to the Fourth Circuit, where the Fourth Circuit found that the exemption was fatally under-inclusive, and it resulted in a First Amendment infirmity in the statute because the statute was regulating speech based on content, and it decided that faced with two different options. Number one is to just strike the whole statute down, or two, simply take a scalpel and sever the offending portion from the statute. The Fourth Circuit chose the latter. And we saw something very similar happen, maybe I think it was a few weeks or a few months later, when the Ninth Circuit took up that very challenge and essentially reached that same conclusion, that A, the exception caused a constitutional infirmity under the First Amendment, and B, the appropriate remedy was to simply sever that exception from the statute to cure the constitutional issue. That was eventually, AAPC sought certiorari of that particular question to the Supreme Court. The Supreme Court granted it, and just a few weeks ago rendered its opinion, which my colleague David will cover.
Thank you, Artine. So the question that the court granted cert to review is whether the particular government-backed debt exception, which was added in 2015, violated the First Amendment, and then if so, whether the proper remedy was to sever the exception or to strike down the entire statute. So there was at least the potential, the possibility existed, that the Supreme Court would decide to strike down the entire TCPA ban on auto dialers. It wouldn't have eliminated other portions of the TCPA, but it could have eliminated the ban on auto dialers. So this is the slide that you're seeing now is how the decision ultimately came out. And I think it's important, and we'll talk just briefly here in a moment, Artine will pick back up. And there was actually a series of different decisions, kind of what you could consider a fractured approach from the court. But these were the main holdings that ultimately came out of the decision. First, and this decision, the primary decision was written by Justice Kavanaugh. the court concluded that the government-backed debt exception did, in fact, violate the First Amendment, that it was a restriction based on the content of the speech, not on the technology, as our team mentioned earlier, and that it was not, when you applied strict scrutiny, it did not survive that test, right? And so they first concluded they would apply strict scrutiny, and then they concluded that it failed to meet the test. That is the more, closely divided question here, with a 5-4 majority concluding that indeed it failed the First Amendment challenge. Somewhat less controversial, and 7 of the justices agreed, that if indeed the provision itself caused the TCPA to violate the First Amendment, that the appropriate way to deal with that was simply to sever the government-backed debt exception and not to strike down the ban on use of auto dialers without consent, which has existed since 1991. And indeed, Justice Kavanaugh's opening statements or opening portions of the decision really focus, I think, on the fact that the ban on the use of auto dialers without appropriate consent is something that is widely popular among the American people. It certainly is popular among many of those in Congress. And I think there was a sense of a pragmatic approach to this problem of whether or not to strike down the entire auto dialer provision or just to take a scalpel, as our team said, to really sever this provision. So where we stand after this decision is essentially where we stood before 2015, right? The auto dialer provision continues to exist, but those that are using auto dialers to try to collect the government-backed debt must have the appropriate levels of consent to use that equipment before they can use it to try to collect on that. So we're going to talk just, again, very briefly, because this is kind of summarizing where the different justices fell. We want to talk a little bit about the different perspectives that they offered in a series of consents and concurring and dissenting opinions. So our team, if you want to pick this up from here. I'm sorry, we're not able to hear you right now.
Got it. That was on my end. We really got a slew of different perspectives, as David mentioned, from the justices. And the main opinion was really broken down into 3 parts, 2 of which are really relevant for our discussion. The first part was just background. So part 2 was Justice Kavanaugh's focus on the constitutional question of whether or not the government-backed debt exception rendered the TCPA a content-based restriction-based, subject to strict scrutiny, which is the highest standard of scrutiny. Very difficult for content-based restrictions on speech to overcome that standard. It requires the demonstration of a compelling governmental interest, along with a few other factors that the courts will consider. The Justice Kavanaugh, joined by Justices Roberts, Thomas, and Alito, and then Justice Gorsuch, separately concurring, found that the restriction with the exception was a content-based restriction on free speech and not rejecting the government's position, just a regulation of commercial activity. And really, once the court found that the constitutional question was a foregone conclusion, because the government didn't really advocate a position that if strict scrutiny applied, that the statute in its present form would survive. So as soon as the justices reached that conclusion, the first question was met. The TCPA with the government debt exception was an unconstitutional content-based restriction on free speech. So that moved the court then to the next question, which is, what is the appropriate remedy? And as you saw earlier in our slides, we had a picture of a scalpel and a sledgehammer, and that's really the 2 remedies that the court was presented with by both sides. Either we can just kind of take out the cancer, so to speak, or we just kill the patient. And not surprisingly, in my opinion, the court chose to just take out that cancer. So the justices, as David mentioned, it was a 7-2 agreement along these lines that the appropriate remedy was to sever. I think one of the more poignant points made by Justice Kavanaugh is that constitutional litigation is not a game of gotcha against Congress where litigants can write a discrete constitutional flaw in a statute to take down the whole otherwise constitutional statute. In other words, kill the patient. The TCPA for 20-plus years operated completely fine, and really the problem was created 20-plus years after its statute was passed when that offending exception was added in 2015. To me, that seemed like a pretty logical conclusion for the justices to reach, and I think the kind of attractiveness and pragmatic nature of that remedy is reflected by the fact that you had 7 justices sign on to that particular aspect of the holding. So we can move on to the next slide. Now, Justice Breyer and Sotomayor offered their own concurring and Justice Breyer dissenting opinions, and quite frankly, they were much more consumer-friendly in the way that they, at least Justice Breyer was, in the way that he approached the statute. Very much friendly towards regulation because he took the position that really a more lenient standard should apply because this content-based restriction, yes, it is a content-based restriction, but it's really aimed at commercial regulation, which isn't entitled to the same amount of protection as the speech that the First Amendment was initially intended to protect, which was, the free marketplace of ideas, and there's really no intersection between the commercial speech that's regulated on the one hand and what the First Amendment was passed to protect on the other hand. And Justice Breyer also found that if you were to apply a intermediate scrutiny standard, which is, again, a more lenient standard than strict scrutiny, that the exception would survive. But he ultimately agreed that even if it didn't, and recognizing that the majority found that whatever standard you apply, that the majority found that the exception rendered the restriction unconstitutional, Justice Breyer agreed that severance was the right call. Justice Sotomayor agreed with Justice Breyer on the standard, but disagreed that it would pass intermediate scrutiny, but ultimately sided with a significant majority of the justices in finding that severance was ultimately the appropriate remedy, regardless of the standard that you apply. And we can go and we'll cover Justice Gorsuch's concurring and dissenting opinion, joined by Justice Thomas as to the severance remedy. Gorsuch, I would say, definitely was the coldest when it came to the TCPA. He concurred with Justice Kavanaugh that strict scrutiny applied, but really did not agree that severance was the right remedy. A couple of points that he made was that the remedy really didn't get anyone anywhere in terms of the relief that the plaintiff was seeking in the lawsuit. It didn't really do much to advance the outcome they were advocating for, and it ultimately ended up actually harming, so to speak, strangers to the lawsuit, which would be, again, entities that were taking advantage of this exception. So he actually took the position that instead of severing it, that the court should have issued an injunction preventing enforcement of the auto dialer ban against the plaintiffs. And there you have essentially the breakdown of the specifics of the opinion amongst and the perspectives of the different justices. We can move on to the next slide. And David, I'll throw it back to you to kick off our discussion, kind of digesting all this.
Great, thanks. I think it's interesting just to pick up for a moment on what the world would look like if Gorsuch's views of this had actually persuaded his fellow colleagues on the court. And in that case, you would have only these plaintiffs, which query how that works when it's an association, right, and of a bunch of members. But he didn't even address that question. But anyhow, you would have these particular plaintiffs who would have won an injunction against the auto dialer ban being applied to them. So they would be free to use auto dialers potentially without having the appropriate levels of consent. But all the other companies that use this equipment across the country would not have that injunction applied to them. So then you would have, even today, it's very difficult for companies to figure out compliance, but could you imagine really trying to to advise and govern your businesses in a world in which each party would have to file a case with the court to seek their own individual injunction, and that the opinion of the Supreme Court really had very little nationwide uniformity. I think that one of the reasons people appeal decisions, and that obviously this association spent considerable resources to go all the way to the Supreme Court, is to try to address the law and get it a uniformity. And if Gorsuch had won the day, we would have ended up with kind of exactly the opposite. So I think that's an interesting sort of dichotomy to think about. So what we have essentially here at this point in time is the auto dialer restriction continues to stand. The government-backed debt exception is gone, and that is really the takeaway from this case. I don't immediately foresee additional First Amendment litigation in light of this opinion with regard to the TCPA. So any other insights before we pass the baton, Martine?
Yeah, just real quick. I mean, I didn't think this opinion made many waves ultimately. I think most people probably had the same gut feel as I did, which was that they'll probably just end up severing the statute. It seemed like, to me, quite a drastic remedy to just wipe the whole thing out. And even if they did, and I think you would probably just see Congress kind of step in to fashion some kind of new law. You know, practically speaking, again, really it's the status quo when it comes to TCPA, the importance of TCPA compliance. And really kind of the change I saw was on my litigation tracker, where I saw more and more student loan servicers being sued in lawsuits quite literally the day after Barr versus AAPC was filed. I'm sure that there was a potential floodgate there that was opened of TCPA litigation against student loan servicers and similar collectors of government-backed debt. And I also think that these perspectives were very interesting and might inform another topic that we'll discuss later, which is what the Supreme Court is going to do with the auto dialer definition. During the course of oral argument, you heard a lot of Justice's comment about how popular this law is. Justice Kavanaugh kicked off the opinion by saying that this is literally the one issue that all Americans can agree on, is that we all disdain robocalls. And so I think those attitudes might very well inform how the justices ultimately end up approaching the next big issue, which is the auto dialer definition. You definitely saw a lot of, you know, kind of, I suppose, favoritism towards the law, as well as a range of opinions, but they really were kind of crowded on the end of the spectrum that is frankly favorable to the TCPA, with Justice Gorsuch kind of over here on the cold end of the spectrum, more or less by himself. So it'll be interesting to see kind of whether or not we see some of these same attitudes trickle down, trickle through to the proceedings that the Supreme Court has now decided to take on relating to the auto dialer definition, which will be covered by Nadia and Nicole in our next panel.
Yeah, excellent. So let us hand it over to Nadia and Nicole, who are going to talk a little bit about this issue about ATDS and the current split among the courts and what the future might look like there. So.
Hi, everyone. My name is Nicole Sue. I am an associate in Wombo's Irvine office, and I'm a part of the TCPA team. And I've been handling TCPA cases for about 5+ years, probably handled over 100 TCPA cases in federal court and arbitration. I often write about the TCPA, which if you haven't checked out our blog, you should definitely check out our blog, tcpadefenseforce.com. It has a lot of great content and a lot of the latest developments and trends on the TCPA. So as you can tell, I live, breathe, and eat the TCPA, apparently. As Artine and David mentioned, you know, this definition of what is an auto dialer is undoubtedly one of the major issues in recent years. So under the statute, the term automatic telephone dialing system means equipment which has the capacity to to store or produce telephone numbers to be called using a random or sequential number generator, and B, to dial such numbers. So at the time the TCPA was passed in 1991, that was precisely the system that was being used to make calls, a system that literally dialed numbers randomly and sequentially. So as you can imagine, it would make calls such as 555-0001, 555-0002, 555-0003, and so on and so forth. But the thing is that nobody really uses that technology anymore. It's just not cost efficient or effective. So as technology changed, so has the FCC's interpretation of what constitutes an ATDS in order to keep up with the times. So in a series of rulings in 2003, 2008, and most recently in 2015, the FCC expanded the definition of an ATDS to include predictive dialers. And there's various definitions of what is a predictive dialer, but in the broadest sense, it's a telephone system that dials from a list of numbers seeking to reach certain individuals. And once the call is answered by the person that they're trying to reach, it then connects the call to an agent. So really, the struggle with the definition of an ATDS stems from the 2015 FCC order. So in 2015, the FCC issued the TCPA Omnibus, which attempted to clarify a number of issues, but primary among them was the definition of an ATDS. So in the order, the FCC reaffirmed its prior position that predictive dialers was an ATDS. But not only that, the order actually went further and to state that any equipment that has the potential capacity to randomly or sequentially generate numbers to dial may qualify as an ATDS. So basically, as long as the system can be modified using some sort of hardware or software to randomly or sequentially generate numbers to make calls, it's potentially an ATDS, even if that function was not currently being used. So a great example is, for example, an everyday smartphone. It presently doesn't have the capacity to randomly or sequentially generate numbers to dial, but it could be modified by adding some sort of software so that it can be turned into a device that can randomly or sequentially generate numbers to call. So essentially, the 2015 FCC order took a very broad approach to the definition of an ATDS. So what happened, as you can imagine, was that over a dozen different organizations sought review of the FCC's 2015 order, which was eventually consolidated into a case called ACA International versus FCC that was heard in front of the DC Circuit Court. And after about 2.5 years of waiting, which actually was a long time because everybody was just waiting for this opinion to come out, ultimately the DC Circuit Court issued its opinion and rejected the FCC's expansive definition of an ATDS. The court found that the FCC's omnibus ruling, quote, fails to satisfy the requirement of reasoned decision-making. And it took issue with the FCC's interpretation of the ATDS for a number of reasons. First, it disagreed with the idea that a device having the potential capacity to make calls randomly or sequentially can violate the statute, even if that function wasn't presently being used. So in the cell phone example, the DC Circuit didn't like the fact that an everyday cell phone could potentially be considered an ATDS. The court was also troubled by the FCC's suggestion that an ATDS must generate numbers and dial those numbers randomly and sequentially, but also suggesting that an ATDS need not generate its own numbers, but could simply dial from a pre-existing list of numbers. So those two definitions seem to be competing definitions of an ATDS. And ultimately, the DC Circuit set aside the FCC's interpretation and sent the FCC back to the drawing board to clarify what is an automatic telephone dialing system. So while the FCC is doing its work, courts across the country have grappled with what is the definition of an ATDS in the aftermath of ACA International. And I'm sorry, I think the slide. Oh, there it goes. Okay, so we have a narrow and broad interpretations. There's two primary different camps of interpretation that resulted after ACA International, a narrow definition and a broad definition. So in the narrow definition, the courts stayed true to the statutory definition and found that equipment that has the potential equipment that can randomly or sequentially generate telephone numbers and dial those numbers is an ATDS. So under this instance, equipment that stores telephone numbers, for example, and makes calls from the stored list of numbers would not be an ATDS. You also have some courts taking a broad approach to the definition of an ATDS, and there they held that to qualify as an ATDS, it must, one, be equipment that stores telephone numbers, or two, produces telephone numbers using a random or sequential number generator. And under this definition, equipment that calls from a list of numbers or a list of stored numbers, for example, would be an ATDS. So next slide, please. So what you see is that we have circuit courts taking different approaches. So you have the 3rd, 11th, and 7th Circuit taking a narrow approach to the definition of an ATDS, and you have the 9th and 2nd Circuit taking a broad approach to the definition of an ATDS. So I'm going to talk briefly, just very briefly, about the 9th and the 2nd Circuit's broad approach to the definition of an ATDS. I mean, you know, we could spend an hour talking about each of these opinions, but if you guys want to talk about it, feel free to email me or call me. But so just very quickly, the 9th Circuit in Marks versus Crunch in late 2018 held that to qualify as an automatic telephone dialing system, equipment must have the capacity to, 1, store numbers to be called, or 2, produce numbers to be called using a random or sequential number generator. Next slide, please. Similarly, the Second Court in Duran versus Laboom held that a dialing system that merely stores a list of numbers, even if it does not store or produce it using a random or sequential number generator, can still qualify as an ATDS. So again, these two courts took a very broad approach to the definition of an ATDS. So if you are using a telephone system that stores numbers and dials from a list of numbers, and you have a case in the 2nd or 9th Circuit, it's very likely that that system would be considered an ATDS under these circuits' interpretation. Now I'm going to pass it over to Nadia, who will talk a little bit about the narrow approach that the circuit courts have taken.
Thank you, Nicole. Hi, everyone. Thanks for joining us. I'm Nadia Adams. I'm an associate in the firm's Irvine, California and Los Angeles, California offices, and I am a business litigation attorney. I focus on litigation in the financial services and consumer goods sector. I represent, as our team mentioned, businesses of all sizes across the country in state and federal court, as well as in arbitration. Matters that I handle include the TCPA and related statutes, such as the Fair Credit Reporting Act and the Fair Debt Collection Practices Act, as well as some state statutes in the same vein. So picking up where Nicole left off regarding the narrow definition of an ATDS, there are, as Nicole mentioned, 3 of the 5 circuit courts that have considered the definition of an ATDS agree with the narrow statutory definition of an ATDS, that to be considered an ATDS, a device must have the capacity to randomly and sequentially generate numbers and dial them. In the 3rd Circuit, Dominguez v. Yahoo, the court, well, let me talk about the facts really briefly because it's a little bit interesting. The plaintiff in that case filed a class action after receiving allegedly 27,800 text messages because he had a reassigned telephone number of an individual who had a Yahoo email account and had signed up to receive SMS text messages every time that he received an email to his Yahoo account. And the number was never changed in that prior user's email account. So every time he received an email, the plaintiff, who had no connection to those emails or to that account other than having the telephone number in common, received a text message. So it was alleged to be 27,800 text messages in 17 months. So the court in that case focused significantly on the issue of whether or not Yahoo's email SMS service had the present capacity to function as an auto dialer by generating random or sequential telephone numbers and dialing them. So in that case, the plaintiff argued that there were several ways that the system could be modified to generate numbers and dial them, but the court
Looks like we're having a little bit of technical difficulty with Nadia's connection. So Nicole, while we wait for Nadia to rejoin us, could you continue with this discussion of the other cases?
Sure. I think she's back.
Listed debt collection. Not actually have not actually randomly or sequentially generate numbers. It was not an ATDS. Further, because the phone system required human intervention, that it could not be considered an ATDS. Then the last is in the Seventh Circuit, the Gaddlehack decision, which hopefully I'm not butchering that name, but the court, in this one, the court commented that, which we've seen in some of the commentaries, particularly regarding the Marks decision, that the act is a grammatical nightmare, but that using a random or sequential number generator modifies both the words store and produce in the definition, and thus had to be able to do both in order to meet the statutory definition of an ATDS under the TCPA. So next, I'm going to talk about the Facebook Inc. v. Duguid petition for writ of certiorari, which was just granted on July 9th, 2020. This is pretty exciting, as David and Artine mentioned. The United States Supreme Court announced that it's going to grant review of the Facebook case. It came out of the Ninth Circuit, as Facebook is based in California, which falls in the Ninth Circuit. And the petition actually presented two questions. The first was a First Amendment question, as David and Artine mentioned, that the court essentially handled already in the Barr case, and we don't expect them to take that issue up again. And so they declined to review this first question. But the second question that they're going to consider is whether the definition of an ATDS in the TCPA encompasses any device that can store and automatically dial telephone numbers, even if the device does not use random or sequential number generation, which is what Nicole discussed. Any device such as like a typical cell phone. So a really important and exciting case that we're going to be watching here at the TCPA Defense Force. So I'll give you a quick, on the next slide, a quick summary of the facts, because I always find that interesting. So Facebook allows its users to opt into several different functions and services. Probably most of us are Facebook users or have been at one time or another. So Facebook has an extra security feature to protect personal information, and it includes a text message login notification that alerts a user anytime a Facebook account is accessed from a potentially suspicious location, like an unknown IP address or somewhere that's doesn't seem to be familiar with your prior location of use. So in March 2015, Mr. Duguid filed a putative class action alleging that Facebook violated the TCPA's prohibition on making calls using an ATDS. He claimed that he never provided Facebook with his number and had not consented to receive any text messages from Facebook, but that he started receiving sporadic texts nonstop in 2014, and he alleged that that was using an ATDS. So why did the Supreme Court grant review on this question, the question number 2? And arguably the reason is to provide a workable, uniform interpretation of the TCPA. As we've discussed, the current landscape is so different depending on an arbitrary situation. Where do you live? Where's the person that you're calling? Are they in the Ninth Circuit? Are they in the Seventh Circuit? Are they in the 11th Circuit? So it's important to get a uniform standard coming out of the Supreme Court, since the circuits are split. Additionally, the statutory text, arguably the statutory text forecloses the Ninth Circuit's expansive interpretation. So that's the grammatical issue, that the text as written just simply does not support the interpretation that the Ninth Circuit gave in the Marks decision. So that's the first issue, and that's also something that the Gaddlehack court commented on with the grammatical nightmare language in its decision. And then, as I touched on, the circuit split, entities and individuals nationwide, whether they be a business or perhaps even based on the broad interpretation, maybe even an individual, face really different TCPA liability based on their geography and the geography of those that they're calling. So if you have a business, there could be really practical differences in your liability depending on the individual you're calling and where they reside. This is a really hotly litigated area of law, as we all know, because we follow this and we blog about it, and we handle these cases across the country. There were upwards of 12,000 TCPA cases filed in the past 3 years. That's a really significant amount of action on this front, and such a significant portion concerns the ATDS issue. And because of that volume, there are just billions of dollars in pending and potential claims regarding the TCPA and specifically regarding the ATDS issue. So those are some of the reasons that are flagged for, we think, why the court probably took up this opinion. And so what can we expect? What are the possible outcomes of the Facebook case? So we think that we've opined that there are at least 4 possible outcomes. The court could do the predictable thing, no pun intended, and either confirm the narrow or the broad definition of an ATDS. As we've discussed, there's a split, so they could just side one way or another. But it's the Supreme Court, so they could do some other things too, some unpredictable things. The second thing would be if the Supreme Court takes a narrow interpretation of the definition of an ATDS, we could see some interesting results if there's a new president next year, because we expect this decision would likely come out in 2021. So is there a new president? Is there a new congressional makeup? Is there a power shift in the Congress? And is there the possibility that prior legislation is reintroduced or new legislation is introduced that affects the court's interpretation of the TCPA, or maybe even, as I point out in number 4, which I'm about to get to, maybe just makes the issue moot. So the third issue is that there's a possibility that there's a new FCC chairperson, and that it would no longer be Chairman Pai, and that perhaps perhaps the FCC would on its own just adopt a new interpretation of the TCPA, which would provide guidance on this issue and perhaps usurp the court in some way, or the FCC could issue an opinion, perhaps not an interpretation, not law, but just an opinion regarding this issue, and perhaps moot that or influence the court in some way to consider something new. So when will we know? We think it'll be about 8 to 10 more months before we have a decision. We saw a flurry of decisions come out in June 2020. So we anticipate maybe a little bit earlier than that timeframe next year, we will hear from the court on the possible outcome of Facebook v. Duguid. And with that, I am going to pass it to Ernesto and Niku to talk to you about our last topic for today.
Thanks, Nadia. Before Ernesto and Niku get started, I just want to make a couple comments on this last slide. For those that are listening, you may or may not be aware that the FCC, since the 2018 DC Circuit decision was issued, has had an open rulemaking underway where it could define what an ATDS is. And so part of the discussion that Nadia was providing reflects the possibility that even though the Supreme Court has granted cert on this question, that action by the current FCC or a newly constituted FCC after the presidential election could ultimately moot the Supreme Court's process, right? Because if the FCC were to release its own interpretation, that would arguably reset the playing field throughout the country. The other option is that the FCC waits, is sort of thankful that the Supreme Court has taken up the issue so that they don't have to address a hot button issue in the context of a national election cycle. But if the decision comes out in a way that whatever party holds the majority of the FCC at the time the decision is released, if they don't like the decision, based on historic precedent, like cases like Brand X, they could still come forward with a different interpretation at that point, right? So we could see action at the FCC or on Capitol Hill before, after the Supreme Court renders its decision, depending on if people feel like they don't like the particular direction that's chosen. So I think it'll be fascinating to see who is really the first mover on this issue. It's obviously a significant issue for lots of litigation across the country. And I also think that if we do get a decision from the Supreme Court, picking up on our team's earlier comments, it'll be the most fascinating part of this will be how the textualists on the court really review and analyze it, and whether the textualists get to the same interpretation, or if even their views of how to apply textualism produces different results. So we'll see if we get a fractured opinion or something more clear this time around if we ultimately do get a decision from the court next summer. So stay tuned. Unfortunately, this doesn't help businesses plan their compliance strategies, but hopefully in the next year, we'll finally arrive at the clarity that we've all been seeking now for about 5 years on this issue. So,
David, if I could jump in real quick with one last takeaway there from this when it comes to just kind of day-to-day TCPA compliance. Yes, one of the biggest issues is the ATDS definition, but there are going to be other aspects of the TCPA that are completely unaffected by what happens with this particular issue. That includes calls made with a pre-recorded voice, and that is technology that's still in play today, right? It's not just traditional pre-recorded voice messages, but you have everything from avatar type systems to ringless voicemails that are implicated in this kind of, untouchable, so to speak, band of the TCPA's regulations. And then you also have the National Do Not Call Registry rules that really aren't at play here. And so even if there is let's just say, business-friendly outcome of these proceedings, then there will still be quite a lot of rules and regulations to comply with, not necessarily, say, for perhaps debt collection industries, but even in that case, debt collectors are using IVR and pre-recorded messages to make outbound phone calls. But the end of the day is that, yes, it will hopefully resolve a very important issue, but even so, there will be plenty untouched from the statute that companies will still need to take very seriously in terms of compliance.
Great. Excellent. Well, thank you, Nadia, Nicole, and our team for those comments. And we're going to turn it over to Niku and Ernesto for our final segment.
Thank you, David. Hi, everybody. My name is Niku Khalifian. I am an associate at Womble's Irvine, California office. I'm a member of the business litigation team, and I focus on financial services, and particularly TCPA litigation. So as we've been discussing, the exact parameters of an ATDS are kind of up in the air, and they've been hotly debated. So after ACA International, the FCC issued a notice seeking public comment on a few issues, one of which, as we discussed, was what constitutes an ATDS. And the FCC considered these comments in ruling on a petition that was filed by the P2P Alliance. So many of you may know what the P2P Alliance is, but for those of you that don't know, it's a coalition of providers and users of peer-to-peer text messaging services for different groups, like schools and nonprofits and other groups. So the petition asked the FCC to clarify whether texts that were sent using a particular messaging platform were subject to the TCPA's restrictions on automated dialing. And this messaging platform was used peer-to-peer text messaging, or P2P text messaging. So what is peer-to-peer text messaging? It's basically communication technology that allows organizations to use either an online platform or a mobile application to send text messages. So the messages go from a single sender to a single recipient, and they initiate a two-way communication. So the particular technology that was in question in the P2P Alliance's petition, it enabled two-way text communication. So it required a person to manually send a text message one at a time, and it also enabled the sender to exercise discretion regarding the content and other features of the text message. So in its petition, the P2P Alliance said that its text messages did not involve the use of auto dialers as defined in the TCPA, and it specifically used the language from the TCPA and said that this P2P platform doesn't include the capacity to store or produce telephone numbers to be called using a random or sequential number generator, which is language that we've seen repeated throughout this panel. And the P2P Alliance, in their petition, they further talked about that the people that were receiving these text messages using this P2P technology, they had given consent to receive these text messages by providing their contact numbers to which the text messages were sent to. So in June of this year, the FCC issued a declaratory ruling granting this petition, and Ernesto is going to talk a little bit more about that.
Thank you, Niku. Well, first, thank you for joining us for this webinar. My name is Ernesto Mendieta. I'm an associate in the Womble's DC office. I'm part of the business litigation team, and I specialize in helping international and national clients with telecommunications and privacy issues, including the TCPA. So let's see what the FCC did here. The FCC first, they took up this petition, and it's worth noting because the FCC has no actual obligation of picking up every petition that it's filed to them. They can decide which specific issues they want to take on, give clarity, and give guidance to the companies. So in this case, they thought it was necessary to give some kind of guidance of what constitutes an ATDS and what does not. So this declaratory ruling, as we will see, has a narrow scope, but it's interesting that they decided to do it specifically considering timing. Being here in the summer of 2020, we're pretty close to November 2020 elections. So this is relevant for the type of technology that campaigns are going to be using soon, right? Campaigns are about to be full swing, trying to contact voters all over. So the FCC was trying to, well, it seems to me that they were trying to give some guidance of what type of equipment and what kind of platforms are not on autodialers, and tell the campaigns, well, if you're going to use platforms with these characteristics, you're going to be able to mitigate your risk under the TCPA because they are out of the TCPA provision. So the FCC, not as a whole, but actually was one of the bureaus, specifically the Consumer and Governmental Affairs Bureau, issued this declaratory ruling in June 25, answering the P2P Alliance petition. And what did they say? They said that whether a calling platform is an autodialer or not, depends on the human intervention. What they said is, if a calling platform is not capable of dialing random or sequential numbers without a person actively and affirmatively manually dialing each of the numbers, then that platform is not an autodialer, and any call initiated or text sent out using that platforms is not subject to the TCPA restrictions. So with this ruling, what the TCPA is saying, and it's confirming because we have seen it in the past, is that human intervention is a key element in determining what is an autodialer. Human intervention has been, it continues to be, and it will continue to be a key factor in determining whether a specific platform or equipment should be considered an autodialer on the TCPA in the point of view of the FCC. So when the FCC describes what a P2P platform is, saying it's a two-way communication when there's a specific sender, a specific receiver, and the sender can manage the content of the text message, if it complies with all those characteristics, then it won't be an autodialer under the TCPA. So the FCC emphasized how human intervention needs to be that key element in the analysis. The FCC also considered the volume or text messages or calls that can be initiated, because one of the comments presented in this procedure was opposing granting the petition, because if the P2P platforms were considered not to be an autodialers, one concern of one of the commenters was that some companies were going to be able to keep sending thousands of text messages out. The FCC said the volume of text messages that you were able to send is irrelevant. The volume is not even determinative, and it's not even probative of whether a specific platform is an autodialer or not. So we should not see the volume of text messages and calls that can be sent, but we should see the other type of characteristics. Like I said, human intervention is one of those key factors. Finally, the FCC confirmed that even if you're using an autodialer to contact a specific recipient, but that recipient has granted express consent, then it would not be violative of the TCPA. So again, this declaratory ruling was narrow in scope, and now let's talk in the next slide what the ruling did not do. The FCC refused to say which specific platforms were an autodialer or not. The FCC made an analysis of what characteristics and what functionalities would make a P2P platform not be an autodialer, but they did not say which specific platforms were. They they refuse to pick winners and signal to campaigns this specific brand or this specific platform complies or not complies with TCPA. Rather, the FCC said this is going to be a case-by-case analysis. Depending on the facts, depending on the functionalities of the specific platform, you're going to be able to determine whether it's an autodialer or not. Also, the FCC in this proceeding recognized that there's the open debate, both in courts, both the FCC's own proceedings trying to determine the definition of an ATDS and the interpretation of that definition. In this ruling, the Bureau said, well, did not weigh on what that definition ought to be in the future. Rather, they said we're narrowing down to P2P platforms, and this is what will apply to your specific, this specific type of equipment, not the ATDS debate as a whole. And it's interesting to note and that it was one of the boroughs that came out with the ruling and not the FCC as a whole with the votes of the commissioners, because it seems to me that this is as far as the FCC was willing to go right now regarding the debate of the ATDS, right? There was pressure of trying to get some guidance for the campaigns that are going to start using these platforms. So the FCC put this out. This is a ruling that helps them mitigate risks, but they were not willing to get into that debate of the ATDS definition. And it's important to know that this ruling came out before the Supreme Court confirmed that they were going to tackle this issue next summer. So what are the practical implications of this ruling? First, as I've said, the timing, we're going to see a lot of usage by campaigns and other type of companies on this type of platforms now that the FCC has clarified that they're not autodialers. Again, the human intervention factor is emphasized. That's one of the key elements that's going to be analyzed in all TCPA cases, which can be taken if there's pending litigation in courts. You now have this guidance by the FCC, which can be used retroactively in those cases. Again, it's a ruling that is going to mitigate risk of using P2P platforms. And finally, we shouldn't see this ruling. As I said, it came before the Supreme Court said they were going to tackle this issue next summer. But we shouldn't see it just as a temporary guidance that next summer is going to end. Rather, seeing it as a narrow decision on what's a P2P platform, I think it won't necessarily be impacted by what the Supreme Court decides to do, whether they want to take a narrow interpretation or they want to go with a broad interpretation of an ATDS. This specific ruling could stand applicable just to the P2P platforms. So I'm seeing we're getting close to the end of the webinar. I'm going to leave you with this. David and our team, I see we have one question in WebEx. I don't know if you want to give a final thought or you want to tackle that question.
If you could read out the question, Ernesto.
Okay. So the question is by Renata Strauss. Thank you, Renata. Does the fact that the ruling came from a borough have any implications for reliance on the ruling in the 9th and 2nd circuits?
So as a general matter, courts typically defer to FCC interpretations of statutes that are governed by, that the FCC has jurisdiction to interpret and enforce. It shouldn't make a determination, in my view, between a bureau level or a commission level decision, because the bureau is operating pursuant to delegated authority. So while there is an opportunity to petition the entire commission to review the bureau decision, unless and until the commission overturns it, it would still be considered a decision of the agency. The only caveat about that is there have become, in recent years, a few different questions and cases starting to challenge or examine what the deference that courts give to regulatory agencies, including the FCC, should continue forward or be modified. But at the moment, at least in my view, I think that most courts would find that this is a decision that fits pretty squarely within the FCC's their sort of legislative powers, because they do have this delegated authority to interpret the TCPA, and that as a result of that, most courts would likely defer to it. But until we see that particular challenge in the courts, it's always hard to know how that's going to play out. But so that would be my view. Well, we are at the 2 o'clock hour, so I first want to thank all of our panelists and my colleagues for putting the time and energy to prepare for the presentation today and for joining the discussion. And I want to thank each of our participants listening in as well for making time to join us. On the screen now, you have our contact information, so if you have any follow-up questions or questions that you didn't want to raise here on this on the webinar, please feel free to reach out to us by phone or email, and we'll be glad to talk with you further. Thanks so much and enjoy the rest of your day. Take care.